Well, the most immediate consequence of a domestic violence charge is Colorado's mandatory arrest law. And what that means is if a police officer, during the course of their investigation, develops probable cause to believe that somebody has committed a crime against an intimate partner, which makes it a crime of domestic violence, then the police have to arrest that person. And that's a lot different than most other misdemeanor crimes and traffic offenses in Colorado. Most DUI charges are summons charges, which means that somebody is served and released from the scene of the crime or the scene of the arrest with a promise to appear for the next court date and contest the charges or plead guilty at that point. That's not the case for domestic violence charges. Police have to make an arrest, and then there's another part of that which states that a domestic violence suspect is not eligible for release on bond until they've signed and acknowledged a mandatory protection order, which is issued in every one of these cases. And so practically speaking, if you're charged with an act of domestic violence, you're held in custody without the ability to post bond until your first court date. Now, the mandatory protection order has a number of conditions. One of those is a non-modifiable condition, which states that you can't harass, annoy, alarm, or retaliate against any victim or witness to the case. That's a standard condition, and what it essentially amounts to is you can't commit a new crime against a person who's listed as a victim of the underlying charges. But there are a number of other conditions that vary from jurisdiction to jurisdiction, but frequently they include a requirement to vacate any shared residence that you have with the alleged victim, an order that you have to refrain from contacting, either directly or through a third party, the alleged victim, an order preventing you from consuming or possessing any alcohol or controlled substances, and then an order that you have to relinquish any firearms or ammunition within your possession. So these conditions, at least most of them, are modifiable by the court, but there's an added difficulty that comes in modifying this protection order, and that is that the district attorney's office has to receive notice of your intent to modify the protection order before a judge will address a modification. And that's because the district attorney has an additional obligation in these cases under something known as the Victims' Rights Act, and that requires them to reach out to any person listed on the charging document as an alleged victim and inform them that the accused is seeking to modify that protection order. And then that person has the ability to provide input to the court on any potential modification. So those are the consequences that come along with a domestic violence charge, but there's additional consequences that come if you are convicted of a domestic violence offense. And that means that if you plead guilty to a domestic violence offense or are found guilty at trial. And those additional consequences include a prohibition on your ability to possess firearms. You're prohibited from possessing any firearms or ammunition for the duration of that conviction, which is largely a permanent conviction. There's some ability to seal the conviction after a number of years, but for the most part, you won't be able to possess any firearms. There's also a condition that if you're convicted of domestic violence offense, you have to complete a domestic violence evaluation and comply with any treatment that the evaluation recommends. And then finally, Colorado has a habitual criminal statute, which enhances a misdemeanor domestic violence charge up to a Class 5 felony charge if you have 3 prior convictions for domestic violence offense.